In parts 1 and 2 of this conversation, I covered how the Calais decision was one of many in a long line of decisions designed to consolidate power into the hands of the rich, white, wealthy, elite males of society. I also covered how one single document, the Powell Memo, was what set the stage and established the playbook for the Republican Party to be able to execute what we're seeing today. That was the great-grandfather of Project 2025. But here's where it gets interesting. In this conversation, I'm going to talk through about how Lewis Powell, the author of the Powell document, did the most damage when he actually got his reins on the Supreme Court. And his rulings have single-handedly stripped power away from the average, everyday working American and handed it off to the billionaires, the millionaires, and their corporate overlords. And that's what we're going to cover in this conversation. So buckle up. And if you haven't already done so, make sure you subscribe, give me a follow. That way you'll never miss another episode of Left in Exile. Let's get into it. Now, it'd be one thing if all he did was write a memo, but he did a lot more than that. And it didn't stop at just writing that memo. A few months later, he ended up on the Supreme Court thanks to Tricky Dick Nixon, who before today was widely known as one of the most corrupt presidents in the history of the U.S. And here's what's interesting. He was nominated to the Supreme Court, but that memo never saw the light of day during his confirmation hearings. It was only after he was confirmed that it was leaked. And what was discovered was that it was a blueprint for big business to attack its critics. But that's par for the course. Republicans have been hiding their judicial nominees' positions on a wide array of issues throughout the confirmation process so that they could continue their efforts of taking over the courts. And once Powell was put into power, he put into play, through his decisions, the corporate counter-revolution. And he helped build the legal architecture that treats corporations like constitutional actors. If you want to understand why later court decisions deemed that corporations are like people, you need to look at the foundation that Lewis Powell put into place. His reasoning in Buckley versus Vallejo tied campaign spending to political speech. His decision in First National Bank of Boston versus Bellotti gave corporations First Amendment rights to spend money on ballot initiatives. Now think about what that means. We right now talk about Citizens United as something that needs to be blown up, and it does. But Citizens United was built on the backs of Lewis Powell's decisions. And when we think about the implications of that decision, meant that while workers have to organize one break session at a time, corporations get constitutional megaphones to do the same thing, to bust up the unions. Workers end up getting busted unions, corporations get speech rights. Workers get told to shut up and be grateful, and corporations get treated like citizens. That's power choosing aside, all built on the foundation that Lewis Powell articulated before he got appointed to the Supreme Court. And when you take a look at those two decisions, that's when this Republican project starts to make sense. Because Republicans figured out something very important. You don't need to win every argument if you can capture the institutions. And those institutions can decide which arguments matter. You capture the courts, you capture the media ecosystem, you capture universities through donor pressure, you capture state legislatures through gerrymandering, you capture the administrative state by starving it and then claiming it that it doesn't work, all at the same time handing off those same agencies and services to your private sector buddies that can funnel cash back into your campaigns. You capture public anger through race panic, gender panic, immigration panic, trans panic, crime panic, school panic. And while everybody is fighting each other, the donor class is picking your pockets clean. That's the trick. And that's what the billionaire class, the millionaire class, and the Republican mouthpieces and megaphones have been doing for the last 50 years. That's always been the trick. That's been the trick since before the founding of this country. Divide and conquer. It's been the plan. Get working people divided by identity, then make sure that they never notice who is actually stealing their wages, their time, their health care, housing, schools, voting rights, bodily autonomy. That is the Republican platform, and that is the Republican architecture and machine. It's a sorting system. The billionaires and corporations get rights, states gets rights, white backlash gets rights, workers get lectures, black voters get suspicions, immigrants get raids, women get surveillance, trans people get erased, and everybody else gets told this is individual liberty, limited government, personal responsibility in action. That's the mythology that they sell you, and that's the mythology that they use to distract you from what they're actually doing. So how does that connect with today? When you look at Louisiana versus Kyle A., that didn't happen in a vacuum. The court has been redefining racial discrimination for decades, and it hasn't been redefined as a material reality of discrimination. It hasn't been redefined as a system that denies people power. It hasn't been redefined as voting maps that dilute black voters. The court has redefined discrimination in a really strange way. It's redefined discrimination largely propelled by conservative thought that has been dominating the judicial majority. It's redefined discrimination as the act of noticing race at all, not the practice of discrimination, not denying people power, not cracking and packing congressional districts, but the simple fact that race is a consideration, that's discriminatory. And that's the insidious reasoning that the Republican Party has used and Republican courts have used that's brought us to today. And it's been a death by 10,000 paper cuts, and it's been a complete scam. They take law designed to stop racial discrimination, then use it to block remedies for racial discrimination, and throw in a little bit of magical thinking, making the statement that we need to be colorblind, because if we put in colorblind laws, of course, the white majority, and particularly the white majority of the Confederate-era South, are going to willingly dilute their power and make sure everybody has a chance at representation. That level of magical thinking is usually reserved for people that do a lot of illicit drugs. And yet we have Supreme Court justices making that sort of leap in logic in their decisioning. And what happens as a result? They take the Voting Rights Act, and every single year since the Voting Rights Act and the Civil Rights Act has been passed, the same states of the American Confederacy have been attacking both of those laws to try to dismantle it. And you have, since Nixon, the Republican Party leading the charge, the so-called defenders of civil rights, has been dismantling anything and everything that they can think of that dilutes the power of wealthy white elite men. And here's what's interesting, and here's how twisted their logic is. They take the Voting Rights Act, which was written to protect black voting power, and they twist it as a weapon against black voting power. That should be on a poster about how to maintain white supremacy, because that is what the court is doing. Section 2 of the Voting Rights Act was amended by Congress after the courts tried to require proof of discriminatory purpose. Congress said no. The law should never cover discriminatory results, because everybody with a working brain understands that if a voting rule crushes black voting power, you shouldn't need to get a handwritten note saying, "Dear Diary, today I did the racism." But that's what the Roberts Court has been putting out, not just in this decision, but several other decisions as well. Now that you have a clear idea of how the Republican conversations about making America great again is actually a straight line that draws from not only the Revolution, but specifically the Civil War, Operation Paperclip, the Powell Memo, and Lewis Powell's judicial decisions, those all set the stage for the reasoning that the Roberts Court has used over and over again when it comes to civil rights. Lewis Powell provided the framework and the playbook for the business class and the judicial class and their Republican allies to transform society into what we see today. But that transformation has been a decades-long process. Depending on how you're making the calculation, you're talking about a 50 to 70-year project of overturning everything that came out of the Civil Rights Act, the Voting Rights Act, and now we enter the next phase of that process, taking us back to the era of the First Republic. And that's what we're going to cover in the next part in this series. If you've liked the conversation so far, make sure you drop me a subscribe, and definitely tune in for the next part where we cover how the Roberts Court is playing a strong role in reshaping society into the ideal vision of the wealthy white elites that control the business class and, more importantly, the Republican Party.